All right, good morning, everybody, and thank you for joining us this morning with Primario on Unpacking the Competition Act. We are very pleased to have you with us today. Just if we may request, please, if you are not the speaker, if you keep yourselves on mute, as well as for better streaming purposes, it is preferred to keep your camera off unless you are the speaker. This will just allow for better bandwidth so that you can stream the session smoothly. We will be hosting a Q&A session where you're welcome to either type your question in the chat box or raise your hand, and we will either refer you or your question to the speaker of your query. If I may begin with an introduction, John is the founding partner of Primario and has practiced competition law for nearly 2 decades in South Africa and across the African region. He has been involved in several precedent-setting cases and has vast experience in competition enforcement and merger control. John has also written and spoken extensively about competition policy in South Africa, particularly the role of public interest considerations in merger control. He serves as a special advisor to the OECD Competition Committee as the only African representative. He leads the American Bar Association's task team for Africa on procedural transparency and was the editor and co-author of Class Action Litigation in South Africa, which was inspired by John's involvement in the precedent-setting class action litigation in South Africa for follow-up on damages arising from antitrust violations. John is recognized by several publications as a leading competition lawyer in South Africa and the region. Mike's intro. Mike is a director at Primario, having previously been a director at Norton's Incorporated. Mike advises clients in competition law matters across several jurisdictions across the continent. With a master's degree in economics and competition law from King's College in London, Mike is well positioned to combine his legal and economic expertise to guide clients in complex merger control matters and investigations into prohibited practices. Mike assisted both the American Bar Association and AmCham in making submissions to the proposed amendments to the Competition Act and engaged extensively with Minister Patel and his drafting team under the auspices of BUSA. Mike is recognized as a leading competition lawyer by South Africa, by Best Lawyers. An active member of the American Bar Association and International Bar Association, Mike has also authored and co-authored a substantive body of literature primarily dedicated to competition law in South Africa. Thank you, Mike. Thank you very much. I will hand over to you now. Sorry, I'm not sure.
And good morning to everyone. I think everyone could justifiably be asking, in light of the recent events, whether or not a session dedicated to looking at regulatory risk over and above standard business operation. Can you hear us, Annika?
Yes, we can.
Annika, can you hear us?
Yes, we can. Can you hear us?
Hello, Annika.
Hello. Can you hear us?
Okay, good. Thank you. And just to we can hear you. Thanks very much. So obviously a session like this. Yeah, we can hear you. I hope you can hear us. Tested this. Can everyone hear me now? I hope. Hi, Annika, can you hear us?
Yes, we can hear you. Sorry, Mike, we were giving thumbs up in case there was a delay with the sound, which I think is the issue.
So it's a slight delay. That's fine. Thanks. So it's John speaking, and good morning to everyone, and apologies for the slight technical hitch, but I think everyone can legitimately be asking the question whether or not a time to consider regulatory issues, particularly after the events of the last fortnight, is justified. I think from our side, it certainly is, and it's more warranted than ever so before. The reason we say that from our perspective, obviously, is that in relation to the recent events, what it does give is an opportunity for business to very ably ask the question whether or not the events which have occurred, and more recently the regulatory interventions and the changes in our law, are warranted, and what kind of activity and action those all necessitate. I do want to touch on the issue of civil society organizations, particularly the role of AmCham. As Annika mentioned in the introduction, we've done a significant amount of advocacy work as a group. That's not just limited to South Africa, but also Southern Africa, and further afield into Africa itself. I think civil organizations are critical at this juncture. They are more important than ever so before. And I'll demonstrate why that's the case in relation to what's taken place as a result of the events of the last 2 weeks, where the Department of Trade and Industry and Competition put forward block exemptions in relation to essential goods. Within that, there's an implicit recognition about collaboration amongst entities at a horizontal level in certain instances. And then we wanted to discuss the meat of today's presentation, because originally when we'd set out to go through this content, obviously we didn't have the events of the previous 2 weeks, but as I said earlier on, it's now more so than ever important to understand what's been taking place in relation to the regulatory environment, to understand it, to be able to navigate that area. And we certainly have, in relation to our engagements with the regulatory agencies, a clear understanding of how to do so, but it's important from a business perspective as to how to engage and to interact in that regard. So in relation to civil society organizations, I do want to ask a fundamental question, which I think is going to come towards an answer towards the latter part of the presentation. Whether or not business, and even organized business, has been complicit by conceding for too long. The reason we think today is a very opportune moment to start discussing and ventilating these issues is, as I'll show, particularly in relation to one of the topics to discuss, which is the role of public interest in merger control and more generally, is there has very much been an attitude from business in light of a very clear approach from the regulatory agencies and the ministry concerned from a competitional perspective, and what can be termed a bit of concession. And I want to show demonstrate at least the impact of what those concessions have been. Now, why I mentioned in the introduction and the role of Angela and Annika and more broadly AmCham and other organizations is it's vital that there is a strong and well-represented business organization which is capable of ventilating the concerns which we believe are very clearly evidenced in recent transactions and recent precedents which have come through, particularly from a merger control perspective, and also in relation to the changes to the legislation which have occurred. Now, there are bodies internationally, and I'll talk to these towards the latter part of the slide deck, but ones we're very involved in discussing the role of not just pure competition issues, but non-competition issues at an international level. But South Africa has certainly played a very, very significant role in relation to this. It's certainly deemed to be a bit of a lodestar internationally in relation to how non-competition factors have become a critical component in relation to merger control. And I'm going to talk to that extensively now, because to my mind, within that, there are significant risks facing businesses looking to conclude transactions and how to conclude those transactions in a timely and effective manner. Bodies such as the OECD and the ICN, and equally even within the Law Society, all need to be utilized. So from a starting point from our perspective, these are certainly opportunities we look to explore as Primario. But I will say, as participants and members of AmCham, it's now more so important as those members to actively support the role of AmCham in ensuring that the points which we articulate now are properly put forward before the regulatory agency is concerned and the ministry is concerned. Now, I mentioned earlier on as to whether or not it was an opportune time to engage on competition issues before a business organization. I think the slide speaks for itself. There's been a massive shift and disruption in relation to business operations across South Africa, and particularly in certain geographic areas. That's recognized. It's been written about extensively. There's very much a sort of build process which is going on amongst a number of our clients and also amongst businesses generally. But the question which is raised, and the point I made in the beginning of this deck, and one which I was going to carry through, is there is certainly an opportunity which comes from this. And This, along with a decision which I'm going to talk to extensively in the form of the Burger King transaction, I certainly believe is a bit of a call to arms, if you like, not necessarily in that form, but amongst businesses to really start looking at the impact of regulatory issues and how those are precluding businesses from operating in an effective manner. As a result of the recent conduct that was very recently last week, there've been a block exemption which has been brought about as a result of what took place. And that's obviously to be welcomed. As lawyers advising in the area, we certainly see this as a positive outcome and one which should be looked at in a very favourable manner. That block exemption exists for a period. It's only for a month, from the 15th to the 15th, July to August. But what it does do is it does enable businesses who operate in that FMCG businesses, particularly, to interact in a manner which is under the confines of the legislation. It's worth noting that it's very important that it's come about, and as I say, it's to be welcomed from an organisation's perspective and also from the private bar's perspective. So to go into the fundamentals, obviously, of that, it does specifically relate to essential goods. It does permit limited interaction, obviously ones which don't go and contravene sections 4 and 5, which are the section 4 is obviously the cartel provisions in terms of our legislation, and section 5 relates specifically to the issues regarding suppliers and customers, so vertical relationships. But it does permit for greater communication between parties who are traditionally in horizontal relationships, and it also enables some form of coordination, particularly amongst producers in relation to that. It's clearly not designed to enable any form of price fixing or collusive tendering amongst those parties, and I think that's quite essential in relation to what is contemplated by way of the block exemption. Again, there's got to be cost justifications, and I know Michael will talk about a couple of these issues a bit later on as to why those are necessitated. And there's a positive obligation in relation to suppliers who have any forms of interactions as to how those interactions should go about. But to keep with the theme of our slide deck, I think the most important element which comes out as a result of this is there's an implicit recognition of a benefit of interaction between parties in a horizontal relationship, but under the auspices of the Competition Act. And why that's very important, and it does go some ways to what I want to say a bit later on, certainly in relation to the conclusion, is that parties now need to be actively aware of what their obligations are, and also, importantly, understand that there are permissible means of interacting between competitors during this period. The Commission itself, in terms of a recent report, has acknowledged the importance and benefit of pro-competitive collaboration between businesses. And why it's, as I say, not an inopportune time to be discussing these issues after what the country has faced and businesses have faced is now more so than ever an opportune time to start considering how best to interact and engage on what we consider to be even more problematic areas of recent legislative amendments and precedent-setting cases. So I'm going to discuss now what we want to, as by way of a fundamental in relation to risks in relation to conducting businesses, particularly from a transaction perspective. In our view, I think the hallmarks of a good and effective merger regime are a couple of fundamentals. There has to be certainty, and in that there's got to be some time understanding the period within which a transaction should be closed and the timing, standard against which a transaction is going to be considered, and obviously understanding as a way of transaction advisors what those likely costs are going to entail. As I'm going to show, I think the South African and regional merger control arena is anything but subject to those. I think those sound fundamentals are very much in question. One of the biggest risks, and I'm going to discuss this in more detail, is obviously the standard against which transactions are now considered. Coupled with what's taken place recently, and obviously some significant transactions, I do think that there are very, very substantial question marks about the subjectivity of our merger control process. Equally, and I'll show this in the cases, there is significant intervention, the threat of significant intervention by not just other parties in relation to the merging parties, but specifically by the government and other entities, so trade unions, etc. What that has meant is the fundamentals and those essentials, which I mentioned earlier on, have been substantially undermined. And I think what that ultimately results in is question marks regarding our merger control regime. And equally, there are significant risks regarding the imposition of conditions which bear little nexus to the transaction themselves. Those are costly, they're onerous, and they carry significant risk in relation to closing out deals. Fundamental question, and when we presented this internationally as well, is whether or not we as South Africa have what could be considered to be something of a hostile merger control regime. As I say, there's an evolution of that standard against which a deal is considered. I think everyone in relation to concluding deals needs certainty as to what that standard should be and against what a transaction is going to be considered. As I mentioned, there's significant threat of intervention, either direct or indirect, and that's significant in the sense that it does lead to question marks about being able to close out transactions. So as things stand currently, and one of the hallmarks of today's presentation is deal making has never been more at more of a sensitive phase. So where does this all emanate from? I think many people are probably used to this in terms of their own participation in relation to the merger control arena, but our Act specifically permits a dual stage test, which is one assessing a transaction in relation to standard competition factors, which is a traditional merger analysis that necessitates interaction across the board from a number of parties, industry participants, customers, etc., on pure competition tests, whether or not that transaction will result in a substantial lessening of competition. But allied to that, obviously, there's the ability to interject with public interest, a defined list of public interest grounds. But the more important point is the evolution in relation to that latter. And if we look at the bottom part of the slide, there have been significant developments in relation to not just the competition agencies, but also the ministries which have led the competition agency. So way back in 2011, I think there was an acknowledgement and a view espoused that the competition process in South Africa, the merger control process in South Africa, was not one which is purely based on traditional competition factors. Again, in 2013, a very, very telling comment was made about the use of the competition agencies to further other agendas. And then finally, this year, commentary made regarding the ultimate role from a government perspective or a ministry perspective as to what competition policy is ultimately about from a South African perspective. Now, a comment which came out in terms of a peer review, although this was a number of years ago, is that there are a number of interest groups who have firmly planted their flags, to use that term, in the competition law process and who are actively involved in that process. So when we look through the case law, I think it's very apparent what's taken place. And to go back to some critical elements of today's slide deck and presentation, it's very important to understand the ramifications of a lot of these interactions and interventions, and also the motivations behind those, because ultimately it's led to where we currently are. And from a South African merger control perspective, as I said earlier on, we're at a very critical juncture. I think a number of cases have come forward. There have been results in relation to those cases, but the most recent has caused significant concern from a deal advisory perspective, and also concern regarding the ultimate role of non-competition factors in merger control assessment. So there's a clear evolution, and what I'd like to term as a bit of a 10-year plan, particularly the latter portion of those cases. So the earlier period, I think everyone's probably familiar with a lot of these, but cases were very much uncontroversial until intervention occurred in the bottom left there with the major Massmart and Walmart transaction. But some of the points we've highlighted on this deck are important, because cases from 2012 to 2018, particularly in the brewery section, were very telling. And there's a comment which was made, which we've highlighted from the Competition Tribunal under the Anheuser-Busch transaction in the middle of the deck there, where an agreement was effectively put forward between parties to cater for public interest issues. Now, why I talk about that particularly is if one looks at all these cases, the vast majority of them were not litigated. And apart from the Walmart transaction, which went all the way to the Competition Appeal Court, all of these transactions were effectively concluded before the tribunal without the necessity of going to the Competition Appeal Court or any other subsequent judicial review mechanisms utilized. That's very, very important because a number of these were done by way of concession between the parties advising the merger parties and the ministry itself. So what that means is there's effectively a set of case precedent which is created through the threat of overt intervention, which could have been brought by the ministry, which was brought in the bottom left case, the Massmark case, which results in the evolution of a very, very serious number of precedent, and that's effectively in the form of conditions imposed on major transactions. Why that's very, very important is that that effectively provides the framework for the changes which come through in terms of our legislation. And as we go through, in terms of that, which are the 2019 amendments to our Competition Act, the inclusion of additional public interest criteria came very easily from the ministry's perspective. Now, I talked a little earlier on about the role of civic organizations, and in particular organizations like AmCham and organizations like the American Bar Association. Not many parties objected vehemently to the amendments which were coming through. And the reason I mention that as an important point for today's discussion is that as a result of that, the vast majority of the amendments proposed, and they were largely ministry-led changes and proposals, came through without significant impasse and were ultimately adopted in terms of the law. But what that means is, if one looks back at the actual conditions in terms of these various cases, and I'm not going to go into all the detail from a time perspective, but the vast majority of these are ultimately then reflected in terms of the case, in terms of the law itself. And why that's important is if you are advising on a major transaction, and one which effectively encapsulates that is the Pepsi Pioneer deal, where a number of the conditions imposed in relation to that transaction effectively reflect what took place for the last 10 years from a precedent perspective, but also represent a number of elements within the amendments to the law. So, as I say, in terms of the red there, the case law provided free rein to drive home the amendments in terms of our law. Why that's very, very important is along comes a transaction which we reflect on the right of the slide, now known sort of colloquially as the Burger King transaction, where a deal which is effectively no impact on pure competition factors is prohibited. It's the first time a deal of that nature has been prohibited. It was a private equity investment in relation to an acquisition of a South African entity, was prohibited purely on the basis of public interest grounds. It's important to understand, as I say, the evolution of the case law. That evolution of the case law ultimately led to free rein in relation to the amendments which were imposed. And when one drills down into the Burger King transaction, which is effectively the acquisition by a private equity fund of a South African entity, there's every reason to understand why the Commission ended up prohibiting that transaction. I think it's very important, obviously, from a business perspective, and particularly from an AmCham and its members' perspective, to understand the ramifications of what's taken place. The law has obviously changed. The law was changed on the basis of precedent, but that precedent was not effectively clear-cut litigation precedent. A lot of it, as I say, was on the basis of concessions which had already been granted during the deal process. And the reason why those concessions were ultimately granted by transaction advisors and by the lawyers involved, to my mind, is purely on the basis of those hallmarks of what's required for an effective merger regime. Parties want to get deals closed, and they want to ensure that they can implement the transaction as quickly and effectively as possible. So, a number of concessions given by parties in relation to major transactions has ultimately led to the situation we find ourselves in now. And the question I raised in the beginning of the slide deck, and one which I'm going to discuss towards the latter part of the slide deck, is has business been too conciliatory in relation to the process? Has business not effectively taken opportunities at the correct juncture to be more, I suppose, antagonistic, if you like, or at least more engaged in the process, and rather than being too facilitatory, interacted a bit more by way of the litigation process which unfolds? There's a clear understanding from our perspective, and equally within business, that parties don't want to litigate unnecessarily, and that's an absolute understandable approach from parties' perspective. But where we are currently is that a transaction of the nature of the Burger King deal has effectively been prohibited purely on non-competition factors. As I said, it's the first one. It's caused significant shake-up in the market, and from an advisory perspective, a number of parties are asking, well, what effectively can be done? So I think in relation to advising, in relation to merger transactions now, parties obviously have to be aware of the risks which are posed by precedent, by the law, and specifically now deal with factors which are not pure competition factors and deal with those very proactively. That necessitates an overt look at what the implications are of a transaction on the non-competition factors. I think we've managed to successfully ensure that transactions have gone through the Competition Commission and Competition Tribunal post the Amendment Act being imposed. And we've done so on the basis of quite engaged interactions, obviously, with the Competition Commission, who are statutorily obligated to look at these factors now. But I think gone are the days where parties can simply avoid looking into the non-competition factors and dealing with those in a very robust manner in order to ensure that transactions can go through and proceed unhindered. The forms themselves, these are the statutory merger filing forms, have been amended. Those amendments effectively obligate you to consider in detail the various non-competition factors, and those are set out. And again, if one goes back to the case law and the evolution of the case law, the changes to our law, it's very clear where those will come from. So in order to ensure that a transaction is ultimately proceeded with and comes through either conditionally approved or approved unconditionally, it's an obligation on parties to really consider these issues in detail. During a recent NEDLAC presentation, the Competition Commissioner himself gave an update in relation to certain elements which I think are quite useful for purposes of advising on transactions and considering transactions. And those would be obviously the impact of job losses, the effect on employees, and remedies which have been considered from parties' perspective to address those, which ironically cater for a lot of what came through in one of the recent transactions, the major transactions. So to conclude on that, we go into the next set of issues, is we are in a new normal. I think the reality from a deal structuring perspective and from a merger control perspective is that factors which have almost been implanted in the process are paramount. They have to be considered. It's not an absolute prohibition on transactions if one item is potentially problematic, and I think that's a fundamental point to bear in mind, that all of those factors that are listed there under the statutory merger folds have a role to play in relation to transaction. It's incumbent on parties now to assess, over and above the pure competition issues, the standard competition issues, those which look at the non-competition issues, to evaluate those, to weigh those up, to interact on those, and to do proper, robust background work before a filing is prepared, and to consider those in some detail. And I'm going to get to the other conclusionary points once we finish off. But I think the fundamentals is, over and above the events recently which have taken place, there is a new normal. That normal does necessitate a lot of sound background work and checking up, but it's not insurmountable, and there are ways in which those can be dealt with and achieved successfully. I'm going to hand over to Mike to deal with the price accumulation issues.
Thanks, John, and good morning, everyone. Right, so I think the next section I wanted to unpack a little bit are in particular the amendments to the so-called abuse of dominance provisions that were also brought about in 2019 as part of a quite a significant overhaul of our Competition Act. And I think there's three preliminary hallmarks to note about these amendments. The first is that we are clearly seeing, much like the public interest factors in merger control, which has been around for some time and has been elevated, as John's alluded to, we're seeing public interest and socioeconomic policies very much take center stage in several abuse of dominance provisions. And we're also seeing the Commission move towards almost a consumer protection agency, which is a clear departure from sort of at least the traditional hallmarks of a competition agency. And allied to that, we're seeing a clear policy decision to favor certain groups of competitors, which, as I'll discuss briefly in the slide, might very well come at the expense of consumer welfare, at least in the short to medium term. And there's a lot of, there's certainly a pause for concern as to whether or not that balance and those trade-offs have been adequately debated, and or I suppose the proof will really be in the pudding, how they'll be interpreted and enforced. But then finally, I think what is also noteworthy is the thresholds for dominance. Although the authorities still make use of the traditional market share threshold, which is, just to recap, if you're above 45% market share, you're irrebuttably presumed to be dominant, and between 35 and 45% of the market, you're irrebuttably presumed to be dominant. So you have the onus of showing that you're not dominant. But we saw, and I'm sure most of you are familiar with this, some price gouging decisions that came out last year, most notably the Dis-Chem and Babalegi cases, where the concept of market power, which is an alternative form of demonstrating a firm is dominant in the market, was very much in the spotlight. And albeit that those cases in the tribunal did emphasize and stress that those cases were assessed under, at that stage, the first lockdown of COVID, there were severe supply shocks, and recognized that there were some abnormal features of the market. The precedent that the tribunal set in those cases do, at least in our view, have some binding force going forward. And why we say that is we think there is an increased risk that the authorities and or private litigants will look to rely on that precedent to try and establish dominance over firms which may not traditionally have been considered dominant, 5-6 years ago or more. And then possibly the most, from a regulatory compliance perspective, possibly the most significant amendment was the removal of the so-called yellow card principle for abuse of dominance infringements, whereas previously a first-time offence did not attract an administrative penalty. That's been done away with, and now a contravention of any Section 8 or Section 9 offence, which are your abuse of dominance provisions, attracts an administrative penalty, which is capped at your 10% turnover. So there's a couple of dynamics at play, and I think this is best illustrated in the price discrimination amendments. Now, the Competition Act has always had a price discrimination provision. It's never been too contentious. It's always been largely consistent with what the precedent is in other international jurisdictions in both Europe and the US. And it really catered for a rule of reason analysis, which says, well, recognizes that price discrimination is inherently a pro-competitive practice. It seldomly leads to anti-competitive effects, and there is at least a possibility for a respondent firm to demonstrate why its price discrimination is ultimately pro-consumer or pro-competitive. And that hasn't been too contentious. The amendments, which were brought about in 2019, introduced a parallel but self-standing test to the traditional price discrimination test. And that is, if we call it loosely, sort of the public interest test, which is aimed at assessing whether or not price discrimination by dominant firms impede the ability of firms who are either small or medium firms or controlled by historically disadvantaged individuals, so SMHs, as we termed them on the slide deck. And that's sort of the category of competitor, if you like, whether they are in any way being impeded from participating effectively in the market. Now, the conflict arises in the most graphic form when we look at what are the traditional justifications for price discrimination. So, for example, different modes of distribution or sales, just the different methods in which goods are supplied to different customers. Those are all well-recognized justifications to a price discrimination complaint. Well, what we've highlighted there in red are quantities. Now, quantity or volume was traditionally and is internationally a well-accepted justification for differentiating prices, and that's usually because there are efficiencies very much linked to those volumes. You know, and the common example is a supplier supplying a customer with a half truck full load or a full load. There's clearly going to be an efficiency in a cost per product with a full truckload versus a truck that's half loaded. That's an often quoted example. But the Act has gone further and has expressly prohibited dominant firms from relying on quantities or volumes in circumstances where it may impede SMHs from participating in the market. So the nub of it really is that price discrimination strategies, which would ordinarily be pro-competitive, efficiency enhancing, and be very clearly defendable under the traditional test, might now very much be objectionable by a certain category of competitors who the Commission is seeking to protect. Now, where that risk is perhaps really bears out even further is the Commission published price discrimination guidelines, which, albeit not non-binding, gives a sense of the direction the Competition Commission, at least, is likely to take in terms of interpreting Section 9 and their sort of internal policy approach to Section price discrimination prosecutions. And the very key point that the Commission says is that when, or contemplates, when assessing whether or not a pricing differential impedes the ability of a SMH to participate in the market, when doing that assessment, they are not going to look at the efficiency or the effectiveness of that competitor in the market. So there is a risk which we have flagged in several submissions, and we hope that the adjudicative agencies, when interpreting this, will adopt a pragmatic and sensible interpretation of Section 9, because there is certainly a risk that on a pure literal interpretation, that inefficient or ineffective competitors might be shored up and promoted and protected at the expense of pro-competitive conduct. Then just what the guidelines do somewhat usefully set out are some thresholds and screening thresholds as to when pricing differentials are likely to attract some form of perhaps scrutiny. So they distinguish between important inputs, which the Commission looks at and defines as an input or product which constitutes at least 20% of a customer's variable cost. And in relation to an important input, the Commission says any pricing differential of more than 5% between your customers and those customers would flag attention. And in relation to all other inputs, which are less important, a differential of more than 10%. And when one looks at pricing differential, you're looking at the net difference. So discounts, rebates, any other trading condition. The Commission is really looking at the ultimate net price being paid for a product. So largely inspired, I think, by the grocery retail market inquiry, but it's a provision which is going to be relied on in a number of sectors, and indeed is specifically relied on in the digital market sector as well, which we'll touch on a little bit later in the presentation. Then, in addition to the price discrimination provisions, there's been introduction of the so-called buyer power provisions, which is a new introduction into the abuse of dominance provisions, which essentially seeks to ensure that dominant purchasers of products impose fair and reasonable conditions when procuring product. There are three identified designated sectors to which these buyer power provisions apply at this stage. It's the agro-processing, the grocery retail sector, and online intermediation services, which again, that relates to the digital market sector. And this is, again, a clear move or departure from the Commission considering competition issues as opposed to playing a more consumer welfare, consumer protection type role. So there's some bullet points there on the slide in terms of what types of trading conditions the Commission might consider unfair, and a lot of it is to do with who bears the risk, the one-sidedness of a procurement or supply agreement, and if it's heavily skewed in favor of the dominant purchaser, a supplier would potentially have recourse in terms of this provision. We haven't yet seen enforcement, direct enforcement of even the new Section 9 price discrimination provisions or these buyer power provisions, but it's no doubt going to be, both those provisions are no doubt going to be relied on with increasing impetus going forward, both by competitors and suppliers, and as well as customers trying to, I think at many times, just negotiate better terms for themselves. So there's going to be a lot of dynamic and interplay between the commercial realities of firms who may be near or thereabout the dominance thresholds and these provisions. We'll leave any questions if anyone has any questions on those two provisions for the Q&A session. I think we wanted to also just get through the digital market sector. Jonathan, if you want to go through some digital markets.
Yep.
And then yeah, we can turn back to the price discrimination buyer power provisions in the Q&A session.
Thanks. So I think there's obviously been significant debate in relation to what's been taking place at the digital markets level. We've been fortunate enough to be able to participate in relation to these debates at an international level, and certainly a lot of the advocacy work that I've done at the OECD, the predominant focus has been on digital markets. They are of quintessential importance internationally, as everyone can appreciate, but are slowly finding some trickle-down effect in relation to South Africa. A lot of debate which is occurring internationally, ones which are discussed, ironically enough, in relation to merger control, are ones which are really at the forefront of what at an international level too. So what we've seen from a policy perspective internationally is debates between the two sort of powerhouses from an antitrust perspective, whether or not there do need to be changes to the way in which the law is interpreted and imposed, a look at changing of proof and lowering of standards as well, and then issues regarding killer acquisitions. So I do think that internationally the approach is going to be one which is, I suppose, of some concern from an advisor perspective, principally because there's so much debate. There are very, very vehement opposing views. The types of individuals who are now heading up agencies internationally have brought a different approach in relation to antitrust, particularly in the US, and that has meant that there's a significant amount of traction for purposes of enforcement in amongst the digital markets there. From South Africa's perspective, it's acknowledged. There have been papers recently produced, and the agency has spoken about this at other forums, most recently before UNCTAD, about it being somewhat behind the pace, or not necessarily on pace, and from their perspective has looked at issues which are probably of some pertinence from an emerging markets perspective. But what is clear is that there's an implicit recognition of the importance of digital markets within the South African economy. So recent policy papers have been written in relation to competition in digital markets. As I'm sure some parties will be familiar with, there's the market inquiry which has been announced and has commenced in relation to the online intermediation platforms, and small merger guidelines have been amended principally to capture transactions which I think from a competition commission perspective seem to have slipped, if you like, the regulatory net. So the competition commission has not being inactive in relation to digital markets, certainly going to be a very substantial area of focus going forward. But a large amount of the approach is going to be formed internationally, if you like. We have seen in relation to the enforcement space and merger control transactions of some significance, and that was the We Buy Cars transaction, which was ultimately prohibited by the Competition Tribunal, principally as a result of intervention of competitors in that. But what was quite apparent in relation to that transaction is a significant interpretation and, ironically enough, a difference of interpretation versus international positions. Go through them. Okay. So.
Yeah, so I think, as John's alluded to, South Africa has very much indicated a more proactive approach to digital markets. There's a clear policy debate in digital markets between Europe and America, really centered on, do the rules need to change for digital markets? Do the standards need to change? Are the concerns and risks that have been raised in digital markets being recognized and enforced? And South Africa has very clearly said they're not going to stand back and wait for the sort of more established jurisdictions to land on a firm policy. They're going to be quite proactive in trying to enforce digital markets. Now, I think our view has been that the current legislative framework that South Africa has, and I think this is acknowledged by the Commission, probably doesn't require wholesale amendments to it or any amendments at all. The authorities probably do have the legislative ammunition, if you like, to tackle concerns or anti-competitive practices in digital markets. What we really do require, however, are agencies and capacity within agencies to really understand digital markets, the risks, ensuring that we are not over enforcing or over regulating a market which is, of course, complex, dynamic, but which runs the risk of introducing very subjective and forward-looking assessments, which might not be justified. So merger control is, I think, internationally one of the key enforcement areas in digital markets, trying to question whether or not firms operating in the digital market space should be scrutinized with more detail at a merger stage, and the whole sort of so-called killer acquisition theory of harm, or reverse killer acquisition theories of harm, where well-established tech players are, according to the theory of harm, entering to markets, acquiring a startup in that local market, where in circumstances where that startup might have provided effective competition to the dominant or the well-established player in due course. And we have, part of the OECD, made a number of submissions on this, but at least raised queries in terms of whether or not the level of under-enforcement is sufficient to justify lowering standards, or to justify placing reverse onuses or reverse burdens of proof onto tech firms. It doesn't, there are a number of reasons, pro-competitive reasons, why big tech firms acquire startups. One is that it incentivizes startups to innovate and develop in the very first place, knowing that they're going to get acquired and by or hoping they're going to be acquired by a big tech firm. But there's many efficiencies why buying rather than building your own startup is more efficient. So there's all these dynamics that need to, I think, at the very least, first be properly understood before one proposes regulatory and enforcement. And I think what the Commission has taken, I think, quite a sensible approach to its digital markets. Its approach to digital markets, I think they've been quite open, at least in terms of the market inquiry, in calling for submissions, in calling for those firms who are involved in digital markets to make submissions, to explain to the authorities where are the pressure points, where are the efficiency, the pro-competitive conduct, where are the concerns, so they fully understand the market dynamics before engaging in enforcement thereof. The authorities also, I think, have the added complexity of jurisdictional challenges, given that a lot of the large tech players aren't necessarily domiciled or even have necessarily a physical presence in South Africa. There are all those dynamics, but those are also policy issues, which I think are still being very much at the forefront of the debates. So just to wrap up on this slide, we've discussed merger control. I think on cartel conduct, the Commission looking at very sort of novel theories of harm about whether or not algorithms can essentially collude, a very sort of technical and IT type theory of harm, which I think the Commission is going to rather follow what's happened in Europe and the US and be too proactive on that. But then certainly on abuse of dominance and vertical restraints, I think the Commission is quite clear that they're going to look at digital markets, particularly online mediation platforms, to identify whether those same concerns that we raised on sort of discussing price discrimination provisions and buyer power provisions, and will apply those terms equally to firms operating on online intermediation platforms. So just to wrap up then on the small merger guidelines, what the Commission has done to try and ensure that tech mergers do not go undetected, which is a risk, has happened in a number of jurisdictions. The Commission has published small merger guidelines, which, just take a step back for those who aren't familiar with it, the Commission may call for any merger, even if it's below the mandatory notifiable threshold, to be notified within 6 months after implementation. So the Commission has been proactive in saying these are the types of mergers that it would possibly or likely call for a notification. So tech firms who have a market share of more than 35% of the market, irrespective of the size of your transaction, if you are acquiring a transaction in the tech space, you will invariably be called to notify that merger. So I think far more enforcement on the merger front for tech firms. And then, as John mentioned, the Commission has published its terms of reference for the market inquiry into the online intermediation platforms. Again, going to look at all kinds of aspects, barriers to entry, anti-competitive practices, self-preferencing practices, most favored nation clauses, a lot of the same types of theories of harm that ones would consider under traditional competition or antitrust enforcement, would be very much at the forefront of their investigation or assessment there, but also how digital markets can assist the category of competitors we've alluded to earlier, sort of HDI and firms or small and medium-owned businesses to participate and grow in the market. So we're certainly going to see far more activity in that space. And as most companies move, or at least embrace an element of digital markets in their business practices, this is something certainly to note and will probably be relevant across the board more widely.
Okay, I think just to conclude from our perspective, as I asked in the beginning about perhaps a too conciliatory approach from businesses' perspective, the way I see it, and having obviously advised in the area for a number of years, and particularly being involved in advocacy initiatives internationally, there's very much a regulatory onslaught. So over and above what South African businesses face as a result of recent events, particularly in supply chain and if you're in FMCG and essential goods, major risks and disruptions to businesses. Going into the regulatory field, to sum up, from a merger control perspective, I think the law has obviously been changed in light of, I would say, questionable precedent. And from our side, that does necessitate a very, very robust approach to merger control. One has to be cognizant of the factors. One has to approach merger control in a manner which now looks beyond just standard competition assessments, but taking into account the factors that I discussed in that area, principally those 5 additional, with the addition of the new tests which have come through in terms of public interest. It's not insurmountable, and that's really the key point. The transactions we've dealt with are ones where we've had very pragmatic and objective engagements with clients, who've also engaged proactively and done the work, the groundwork, to be able to interact with the competition authority. But the rules have changed, the law is different, and there is certainly the perception out there, which might be incorrect, that transactions are very much under threat. I think they can be dealt with, and they can be dealt with pragmatically and effectively, and also concluded upon bearing in mind the hallmarks of the merger control regime. In relation to abusive dominance, I think Michael's been emphatic in relation to the changes which have come through. There are new standards, they're very subjective, and there are concerns about the impact of those subjective factors when they're ultimately utilised in assessing the role of firms which are considered to be dominant. Equally, in relation to online platforms and just the digital markets, there's serious, I suppose, regulatory challenges coming through there as a result of what's going on. But I don't think South Africa is an island in any way, and what's been taking place internationally, and when I do speak internationally, issues which we grapple with are certainly not South Africa specific by any means. And why I asked the question right in the beginning of the slide deck, and I think it's really a fundamental from a business perspective, is it's now more so vital than ever it was before that business is utilizing the relevant platforms that they can. Obviously, AmCham provides that. We've certainly looked to utilize that as lawyers in the past. We made representations on behalf of AmCham to try and challenge certain aspects of the changes to the merger control and other dominance elements of the legislation. AmCham was very active. As I said in the beginning of the slide deck, Angela has spoken obviously a lot, and I think it's to be welcomed, but it has to be a continuous process. And what can't happen, and this is really a concern from my perspective, is that too many concessions come out from a business perspective. It's obviously difficult because you're weighing up the risks of litigating, but I think a lot of these issues need to be properly discussed and ventilated before judicial review processes, before the superior courts, and actually looked at in a far more robust manner than they have been. Again, internationally, you can see that the situation is not too dissimilar, but it doesn't mean that parties can't look to utilize the correct means available, and, as I say, utilize organizations similar to obviously like AmCham, which we've done and continue to do so. So, Annika, from our perspective, that's it, and we're obviously very grateful for the opportunity to present to you all. Unfortunately, we couldn't see the participants or the hands, etc. So I do apologize if we were a little bit delayed in relation to it all, sort of waiting for reactions. It's always bizarre looking at a screen but not seeing anything. So I hope you did get an opportunity to listen intently, but we'd obviously welcome questions from everyone's perspectives and get your thoughts in relation to the process, because we're at a very, very important juncture, if you like, in relation to the regulatory regime and the landscape. And I certainly think business needs to be very, very coordinated under the auspices of the Competition Act, but to really take the opportunity to look at ventilating concerns that should come about and to do so with government, because there's an opportunity here. Thank you very much.
Thank you so much, Mike. Thank you so much, John. So we haven't received any questions as yet. So now is the time. If I may hand this over to the participants, you're welcome to either type your question in the box and I will read it out for Mike and John, or you can read it out yourself if you'd like. You're also welcome to raise your hand if you have any comments or queries or questions. As the saying goes, speak now or forever hold your peace.
Well, I think that's an hour up, Annika, but from our side, you know, you're welcome to send questions through to AmCham. Again, thank you very much for our opportunity to interact and engage on this. I think there's very much a positive obligation on business now to look to utilize these platforms and to really interact in relation to the regulatory regime, because it's not one without challenge, as we've articulated, I hope comprehensively. There are ways in which to navigate that and to deal with it in a manner which ultimately is successful. But you need to be aware that there are major hurdles in relation to operating in the current environment over and above. So obviously, please send those through to Annika or to Angela. We'd be happy to deal with those again going forward.
Absolutely. Thank you very much, Mike. Thank you very much, John, for approaching us to do this session with our members. It was truly invaluable in terms of information and enlightenment. Participants, please email me your questions. I'll send them on to Mike and John and they can answer. We will also share a copy of the recording with you along with Mike and John's contact info for your information. And we have finished on the hour. Absolutely. Thank you very much. Have a safe day. Goodbye, everybody.
Everyone, bye-bye.
Thank you. Bye.